Good day. I am Benedict here. I will be presenting a summary of a study performed. The study is called, or the article that's presented is called The Critical Importance of Ballistic Evidence to the Courts in South Africa, which is a summary of research studies performed in order to obtain the Doctor of Policing degree from Tshwane University. So, looking at the introduction, this article summarizes the importance of ballistic evidence to the courts. Recently, there has been increased scrutiny of the ballistics field within South African courts, with the defense teams arguing that it is not a forensic science. For this study, a qualitative methodology was employed to gather data. Articles from various platforms and interviews with participants were utilized, along with transcriptions from selected court cases. Non-probability sampling was utilized in the form of purposive sampling. And the purposive sampling method provided authors with the opportunity to handpick participants who were suitable for the research. A total of 15 key informants or participants were purposefully sampled, and they were experts from the South African Police Services, who were 9 in total. Then from the National Prosecuting Authority were 4 participants. Then there was 1 private analyst, and as well as 1 private attorney. And the least experienced analyst had a minimum of 7 years experience of working experience within the environment of ballistics. Thematic analysis was chosen as a method to analyze the collected data. Now, forensic science is defined involves the examination of crime scene evidence using standardized and proven foundational principles with the aim of assisting the court in making informed decisions. Firearm evidence is becoming a crucial part during court cases, and ballistic forensic examiners or analysts that testify during these court cases considering themselves as experts according to the law. Tseko in 2023 points out in a news article that the defense in the Senzo Mahiwa murder trial is seeking his own ballistics expert to challenge the evidence of the state's ballistic expert. Ballistics is a unit operating under the Competent Forensic Science Laboratory, or FSL, in the Division Detective and Forensic Services of the South African Police Service. The researchers observed an email by Benedict in 2019 that raised issues of concern and proposing the intervention of the development of the following, which was suggested, and a need to address, as it says, issues of concern. And one of that was an adoptable pro forma ballistic court report, which will address the scientific principles, scientific validity, error rates, and examination process of evaluation, comparison, conclusion, and evaluation with reference to Daubert standards. What became evidently clear is that there is an absence of a foundational argument that analysts can rely upon and easily respond to during the addresses by critics and cross-examinations. During the Section 174 application in the matter of State versus Conradi 2018, the defense is of the opinion that the analyst during a testimony did not provide any scientific basis of the accuracy of a bold statement of individualization to the court. The State versus Sakasayo matter in 2019 is another case where the defense is of the opinion that there is insufficient scientific basis for admitting evidence seeking to link a particular component of spent ammunition to a particular firearm, and that the court should therefore exclude all the ballistic evidence tendered by the state. Considering the fact that ballistics-related evidence forms such a critical part of the prosecution in court cases, it is necessary to inform not only the analyst, but also the general public of the fundamental material of ballistics. This study has reiterated the importance of ballistic evidence during court judgments. Looking at the results and discussions, this study has pointed out that the importance of a 212 affidavit. If all requirements have been met, that the conclusion of the examinations performed can be credible evidence, as prima facie suggests during criminal matter in the court. The researcher highlights some of the important experts of ballistics and analysts as pointed out by the courts. Analysts should possess knowledge, training, and experiences of the specialized field that they are about to testify. The court considers microscopic comparisons as reliable. The court does not dispute the foundational validity of ballistics. The court accepts the statements of analysts regarding their opinions to individualize firearms. The researcher also highlights some of the flaws by analysts during court proceedings, which include analysts omitting to provide proper explanations for the opinions that they express, then failure to complete all prescribed documents, the taking of photographs of all positive microscopic comparisons at the time of the examination and comparison. Several significant errors contained in the 212 affidavits of the analyst. Then the defense also mentioned that the analyst made a blank statement after matching two fire cartridge cases. It is clear from court cases discussed during this study that the aspects that are targeted by defense attorneys and critics are the following. The scientific foundational validity of ballistics has not been proven. The accreditation status of the FSL, subclass characteristics, the fact that it might be confused with individual characteristics, the subjective interpretation of comparison results, the unavailability of photographic evidence, displaying the proof of identification marks, the non-existence of a known error rate to verify reliance on analyst accuracy, statistical standards to make identifications, and the absence of black box studies. This study has pointed out that in the USA, two standards are employed as a gatekeeping role to ensure that ballistics examinations and testimonies are valid and reliable, namely, the Federal Rule of Evidence 702 and the Dorbit 509 US at 596. Opposed to this, in South African courts, there is no gatekeeping system. The analysts only have to meet the requirements of the 212 affidavit. Participant 6 has pointed out that the authority to prosecute rests with the NPA, and thus no other gatekeeping system exists. The study has determined that the evidence of ballistics is extremely important to the courts, and it can assist the courts in reaching conclusions in firearm-related cases like murder and robberies, just to name a few. The court in the matter of State versus Akasayo has accepted the fact of firearm individualization and thus make it easier or confirms that such evidence has a rightful place within the criminal justice system, if correctly, reliably, and convincingly explained of all the processes involved. This completely overpowered the argument of participant 3 that states that ballistics examiner comes to the court to give an absolute unqualified statement. The court in the matter of USA versus the Montclair has outlined and confirmed its acceptance that the fundamental validity of firearm individualization evidence is completely met the requirements of the Dover standards. Then, looking at recommendations, analysts should take cognizance of the fact that their evidence is considered irrelevant and they are not the ones to determine the fact or facts at issue, but that determination resides with the courts. Analysts should ensure that they testify with clarity and precision. Thus, it is recommended that these local analysts, during casework, create a microscopic database in the form of microscopic comparison photographs of identifications to build a profile. The microscopic database can be utilized for demonstration purposes to the court in addressing the issue of best-known match and best-known non-match and subjectivity. This will prove the analyst's experience being exposed to such a huge variety of different kinds of markings appearing, thus building a threshold of evaluating him or her. In the context of a court setting, one model that can be utilized to provide assurance of fundamentals of ballistics is the expert witness model. The researcher recommends that this model be developed to ensure that analysts presenting their documents and the findings to the court have the necessary training, expertise, and credibility to provide reliable and unbiased information. The expert witness model is illustrated as follows. Number one would be the legal qualification of the analyst. Number two will be the foundational validity of the science or of ballistics. Number three will be reported or published error rates of the ballistic environment. Number four will be research conducted within the environment, ongoing research, past research. Number five will be a list of references or glossary terms, specialized terms used within the environment. And number six will be the quality management system, especially SOPs involved in current examinations at discussion during the court cases. Then the conclusions reads, the study concludes that ballistics as a forensic science is extensively studied and enables analysts to perform examinations and provide conclusions to the criminal justice system. By implementing the expert witness model, courts can rely on qualified and credible analysts who provide reports, documents, 212 affidavits, or testimonies that ensure the court of their expertise. This practice will enhance the accuracy and reliability of expert evidence, promoting fairness and justice in legal proceedings. Thank you very much.